Hey guys, welcome to Hip-Hop ClariTea, where we don't follow the noise, we follow the receipts. Because in this culture, the story is one thing, but the truth, that's something else. Let's get into it. Now, before we start, as always, I need y'all to pay attention. And don't forget to like, share, and subscribe. Okay, y'all. We need to clarity some things, if you will, because I've been seeing the same headline everywhere. Papoose put a lien on Remy's house, right? And I originally thought that as well, okay? But when I looked at the actual document that's circulating, there's a little problem with the description, okay? Now, the document doesn't say lien. It says Notice of Lis Pendens. That's not the same thing, okay? Now, I have not independently authenticated the complete filing yet, and I don't know if I'm going to or not, but there's a missing section called Schedule A that's also being referenced in this document, and I'm assuming that's the layout of the house, okay? So I'm going to explain what this document appears to be if it is truly authentic, okay? And actually what it doesn't mean as well. And then we're going to look at something even more interesting. Now, if we need to pay attention to if Pat and Remy actually fight over this property, what could each side argue? Because if I remember correctly, Remy's name being the only name on the deed matters. Now, it doesn't necessarily settle the argument, but it does matter. Okay, so first, let's make sure we understand what lis pendens means, which I'm going to go ahead and assume this is Latin, right? But let's forget the legal language for a minute. Basically, lis pendens is this big thing like a flag saying, "Wait a minute, wait a minute, wait a minute." Okay, this is there's something that's attached to this real estate, right? This is more of a public notice saying, "Hey, there's a lawsuit happening that may affect someone's right to this property," right? That's what the lis pendens mean. It doesn't mean that Remy Ma owes Papoose any money or anything like that, okay? Papoose owns half the house either, okay? So I want to make sure we're clear with that. It doesn't mean that Remy owes Pap any money, and it doesn't mean that Pap owns half the house, okay? It also doesn't mean that a judge awarded Pap the house at all. Okay, so it basically is telling you that Papoose didn't win anything. He put a list pendants on the house that basically says there is an unresolved legal claim involving this property, and anybody thinking about buying it, financing it, or taking some other interest in it needs to know about the lawsuit that's involved with this house. That's what this means. Okay. So, with all that said, does that mean that this is a lien? No, it is not a lien. And I think that's where I think a lot of the reporting is confusing people, including me, because I thought it was too. Okay. So, in basic terms, a lien is actually a legal claim or an encumbrance against the property, commonly associated with a debt or obligation. But a lis pendens, when I'm going to spell it again, LISPENDENS, is a notice that's pending litigation may affect the rights to the property. So, like, here's my easiest example, all right? Imagine a giant sign sitting in front of the house saying, "Court case in progress. The court hasn't decided everybody's right to this property yet." Okay? That's closer to what we're dealing with right now. Okay? Now, here's the $1 million question, right? Why would, and I'm just going to use his name, why would Willie file one? And just in case y'all don't know who Willie is, that's Papoose. Um, this is where the filing starts to make more sense, okay? Let's say Pap is claiming that this property should be considered when our marital assets are divided, all right? Meanwhile, the property is titled in Remy's name. Until the judge determines whether Pat actually has equitable interest, the list pendants helps preserve his claim interest. Okay. So, in practical terms, it makes it much harder for someone to simply sell, transfer, refinance, or otherwise deal with the property as though no dispute exists. Okay. Now, it doesn't necessarily make a sale physically impossible, right? But imagine being a buyer or lender and your title search says, warning, active divorce litigation may affect rights to this property. You're probably not saying, "Oh, that sounds wonderful. Where do I sign?" Okay. So the list pendants puts the world on notice, and this is important. It's not inherently a weapon available only to Papoose because he's the plaintiff. Because as you know, since we've seen it, Papoose publicly filed for divorce against Remy, even though Remy had the paperwork ready for mediation, he wanted to show off, right? But under New Jersey law, either spouse can potentially protect a claim interest in the property subject to equitable distribution. So Remy could have done it as well. She could have done it as well. So hypothetically, if the roles were reversed and Papoose, for instance, had the property that Remy claimed was part of the marital estate, she could potentially seek similar protection. Okay, I'm hoping this makes sense. And now we get to a pretty good part here. See, let's make something extremely clear. Remy's name being the only name on the deed now does not automatically mean Papoose has no possible equitable distribution claim, right? See, New Jersey divorce law doesn't simply say whose name is on the deed. Okay, case closed, right? A court first has to determine whether the property itself is eligible for equitable distribution. Okay, so that's totally a different type of question than whose name appears on the title. So Papoose potentially may have an argument, but Remy potentially has an argument too. And see, this is where I want to look at both sides. So, you know what we're about to do? We're about to play hypothetically, okay? So, let's start with Papoose first, okay? Hypothetically, what can he argue? Well, his strongest basic position could be that the property was acquired during our marriage and is part of the marital estate, right? He can argue that even though Remy's name is on the deed, and even if Remy supplied the purchase money, the money used to purchase it was marital money, okay? And that's a huge distinction. If Remy earned the money during the marriage, simply saying it came out of my pocket doesn't necessarily make it a separate property. See, New Jersey also recognizes financial and non financial contributions to a marriage. So Papoose doesn't necessarily have to provide canceled checks showing I paid, for instance, $300,000 towards the house. He could potentially argue that he contributed to the marital partnership in other ways and therefore has an equitable interest in assets acquired during that partnership. And New Jersey actually starts with rebuttal presumptions that both spouses made substantial financial and non financial contributions to income and property acquired during the marriage. So, even though he says, I didn't personally pay the purchase price, that doesn't automatically equal I have zero claim. Okay. Now, let's talk about what may not work for Willie. Okay. Simply being married to Remy doesn't automatically entitle him to half of everything either. Okay. Equitable distribution does not automatically mean 50-50. That's what people need to understand. And filing the list pendants certainly does not establish half this house belongs to Papoose. He still has to have a viable underlying claim concerning the property. And if Remy's attorney can establish that the property is not subject to equitable distribution, that becomes a serious problem for his lis pendens. Okay, because the thing is, New Jersey's court has specifically said that a lis pendens can be filed against property potentially subject to equitable distribution, regardless of whether it's titled to the plaintiff or the defendant or both. But if the property isn't subject to equitable distribution, the lis pendens should be vacated. Okay? So are we understanding this? So the real fight isn't whose name is on the deed. Actually, the bigger fight is this particular property part of the marital estate? That's what we're doing. Okay? Now let's flip the table a little bit. We're going to do the hypothetical game for Remy now. Okay? So Remy's first argument could potentially be yes, we're married, but this property here is not something Willie is entitled to receive. And that's where the purchase history becomes extremely important. See, there's information we still need to independently verify concerning reports that Remy paid approximately about what $1.1 million cash for the property. Because even if that's true, like we need to know where did that 1.1 million come from, right? That's the $1 million question. Like literally. If it was marital income earned during the marriage, Willie potentially has a stronger argument. But if Remy can trace this purchase back, excluding from anything that's equitable distribution, her argument could look very different, right? So simply saying, well, Remy paid cash doesn't always finish the analysis. We have to actually follow the money. Now, let's assume for a moment that the property is marital. Okay, it is, right? Let's assume. That still doesn't mean the judge has to hand Papoose the house. All right, those are two completely separate questions. The court could determine that Papoose has some equitable interest while still deciding that Remy should retain the actual residence. Now, the question is why? Well, New Jersey tells judges to consider things like the economic circumstances of both parties, their income and earning capacity, and who contributed to acquiring and preserving the property, the tax consequences, debts and liabilities. And here's a really important one: the need of the parents with physical custody of a child to own or occupy the marital residence. So, hypothetically, right, Remy's attorney could argue, hey, my client has and can financially maintain this property. She has been responsible for it. The child resides here. Remaining in the residence provides stability. Therefore, even if there is some marital interest to dispute, Remy should retain the actual home. Okay? School continuity could potentially become part of that larger stability argument if the fact supports it. All right. And here's another question that I think that we really need to understand. What about Papooses' ability to afford the house? Let's hypothetically say Papoose can't afford the property taxes, the insurance, the upkeep, and other expenses associated with $1 million home. Okay. Now that doesn't necessarily prove that he has no equity, although you things have been reported, but we're gonna stick here, okay? Now, does that awarding of the house actually make financial sense for Papoose, right? So just got to look at that. So a judge doesn't necessarily have to divide a house with a chainsaw, you know what I mean? If Papoose were ultimately determined to have an equitable interest, there could potentially be other ways to account for that value when distributing the overall marital estate. So Remy attorney could argue, even if Papoose has some equitable claim, awarding him the physical property is neither practical, or equitable. And that's very different from Papoose gets nothing, right? So now let's go through what each side may have trouble with. And here's the simplest way I can put it. For Papoose, potential strong argument would be this property was acquired during our marriage and should be considered as part of the marital estate. But the problem could be if Remy establishes that the property or the funds used to acquire it are legally excluded from equitable distribution, his claim could become much weaker. And the fact that he filed a lis pendens does not prove his claim is valid. I want to make sure we're clear of that, okay? It does not prove his claim is valid. Now let's look at Remy's strongest argument, right? Now, her attorney can argue that the property is solely titled to her, right? That she supplied the purchase money, she financially maintains it, and there are economic and family reasons why she should retain the residence. The potential problem I see she has in this is basically that the deed itself alone does not necessarily defeat Papoose's equitable distribution claim. And saying I paid for it may not be enough if the money she used was a marital property type of money. Okay. And that's why this list pendants makes more sense now. The list pendants doesn't decide which one of those arguments win. Okay. It essentially saying don't let anything happen to this property until we figure this thing out. I want everybody to understand that sometimes things are filed just as a placeholder. That doesn't mean a person is winning or losing or what have you. It's a placeholder right now. Okay. And that's why I don't think we should automatically portray this filing as Papoose is trying to take Remy's house. Although, eh, I'm just going by what it stands for. I'm not saying the intent. I'm just that's different. What list pendants stand for and what the intent of Papoose is doing is totally two different things to me. Okay? The reason why he's doing is totally two different things to me. Okay? And I want to be clear. Maybe he's ultimately seeking like some portion of its value. You know what I'm saying? And I'm just gonna be for real, we don't know. But again, his intent is so different. Um, take it for what it is. All right. But I want to be clear about this document because the document itself is more accurately understood as I'm claiming an interest involving this property. Preserve the situation until the court determines whether my claim has merit. Okay. And Remy's response can essentially be, okay, now prove you're entitled to it. And because since he put it out there, the burden of proof is on him. You understand what I'm saying? So yeah, it looks very shocking, but now he got to prove it. Can he do that though? See? Now, another good question that I think should be answered here is could this be holding up their divorce? I mean, yeah, but is this the reason why it should hold up the divorce? See, is this the actual intent or is this used in the actual intent? And what do I mean by that? Is this a play? Right? Because he really didn't have to do this, right? It could possibly hold up the divorce, and we're going to talk about that. Or he could have done this because he's delaying wanting to marry Clarissa. Because we know what it is. We already know what it is. Papoose don't want to marry that girl. He don't even want to get that girl a baby. But since he sat there and told that girl, and she's pushing it, don't think that he's not hearing about that divorce every day from Clarissa. Don't think. So what he's doing is all these different stalling tactics, in my opinion. I'm gonna say in my opinion only, he's stalling. He's doing every tactic he can to hold up this divorce. Because I don't even think it's about the point of him wanting the Remy back either. I think it's the point of punishing Remy for not wanting him and also trying to use this as a cover for him not to go any further than what's going on right now with him and Clarissa. You can tell by the tattoo. Yeah, let's talk about that real quick, and then we're gonna wrap back up on here. But that tattoo that we've all seen on his left arm that he can cover up real quickly with the sleeve. Well, notice we didn't see none of it last night. That fight that she had, when was it, this weekend? He didn't show that tattoo this weekend. He didn't show that tattoo this weekend, but they made sure to hide the tattoo he had on his forearm that still shows Remy. So let me get this straight. You're such a bird that you're so happy that he got your tattoo, and you had the audacity to say, well, maybe it's the tattoo, that's why we think alike. What you think he thinking about when he got that tattoo of Remy on his forearm still? Who you thinking like then? Because y'all have to cover that. And we didn't even see that brandished tattoo that he showed a movie clip of on IG. We didn't see that none that night. But we seen when y'all was hiding Remy's tattoo though. But let's get back to this. Okay. Could this be the reason why, or could this be the reason the divorce is being held up? Again, possibly. I can't say that it is, but it feels like it's a tactic, right? But let's talk about the equitable distribution again. That still remains disputed. The property issues absolutely could be among the matters preventing a final resolution. Again, I think that he's using this as a tactic, right? But to be fair, we don't have enough evidence to see what was filed and to establish that the property is what's causing the delay. We don't have that information, right? We don't have the information to know if that's really causing the delay or not. But I'm gonna say that to me is being used as a tactic. Okay. And what we can say is this: as of the date of this purported filing, which was in 2025, Papoose was asserting that the divorce litigation affected rights concerning the New Jersey real estate. Okay, that makes the property a legitimate question in understanding what's happening between both of them. That's what I can say. I can also feel in my heart that he playing, okay? But we're still missing something, right? And I spoke to this a little bit. The document does reference that Schedule A that's attached, right? But we don't have Schedule A, which okay, that's fine. But see, that's important because it should identify the property affected by this particular notice, right? Until we can independently obtain the complete record, I am also not going to claim that this is the only property that's involved because we don't know. All right. He could be pulling out all the stops to be holding this up to me. That's how I feel. So here's where we land with it, okay? A list pendants is not the same thing as a lien. Also, let's be clear. It doesn't mean Remy owes Papoose money. It doesn't mean Papoose owns half the house. It does not mean that Papoose won anything. And Remy's name being the only name on the deed doesn't automatically mean that Papoose loses as well. The court potentially has a much bigger question to answer, and it is this property subject to equitable distribution? If yes, was it worth? What is it worth? What did each person contribute? What is each person's equitably entitled to? And finally, who, if anyone, should actually keep the house? Those are different questions. And that's why one little piece of paper called Notice of Lis Pendens tells us something may be happening with the property, but it absolutely does not tell us who's going to win that property fight. Okay. So again, until we get the Schedule A and more of the actual, divorce pleadings, the property tea is officially still brewing here. Now, again, this was just for commentary, education, criticism, discussion that was based on what was publicly being circulated. All right. Of course, this is not legal advice or what have you. The hypothetical arguments discussed here are examples of positions that parties could potentially raise under the New Jersey law. Okay. Basically, I'm trying to tell y'all I'm not a lawyer. It's just I started asking questions and trying to figure this out as best as I can. I have no privy to any information whatsoever, but I wanted to be clear about the difference between a lien and a list pendants. Okay, that's what my whole focus was on this part here. So, as always, can y'all please, please, please like share, and subscribe, and hype me up. Hype me up. All right, y'all. This has been Hip Hop Clarity. This is all I have for you. Bye.
For hip hop, this is hip hop of the day. I give props to hip hop, so hip hop, hooray! Oh!
Ring a ding ding!